and begin the broadcast. And I'm going to let all the law clerks in. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-1180, Finnbin LLC petitioner versus Consumer Product Safety Commission. Ms. Hartnett for the petitioner, Mr. Winnick for the respondent.
Morning.
Morning.
We can start it whenever you're ready.
Good morning, Your Honors. Excuse me. And may it please the court. Kathleen Hartnett on behalf of petitioner Finnbin. I would like to reserve 3 minutes for rebuttal. Your Honors, this case is about an agency that, out of a perceived sense of urgency, acted in excess of its statutory authority and contrary to the evidentiary record before it to promulgate an overbroad rule banning all previously unregulated sleep products for infants, existing or future. This is precisely the type of agency action that the APA is designed to prevent. Section 104 of the Consumer Products Safety Improvements Act of 2008, referred to as the CPSIA, is the authority invoked by the Commission as the basis for the rule we challenge. Section 104 is a streamlined authority that allows the Commission to transform voluntary standards for durable nursery products into mandatory ones by accepting them as is or increasing their stringency. Section 104 does not apply where there's not an applicable voluntary standard. If there is no voluntary standard for a certain class of products, the Commission may regulate the products at issue under its general powers under the CPSA, the Consumer Product Safety Act. The Commission concedes both in the
How do you reconcile that view with the feature of B2, which has a reference which requires the Commission at the end of a process to have promulgated standards for all such product categories, and the such refers back to the nearest reasonable referent in B2, which is durable infant or toddler products?
Thank you, Your Honor. That is the part of the statute that the government focuses on, the timetable section. And I would jump back to the B1 first, but I'll answer your question directly about B2. B2 has to be read in reference to Section 1 because prior to the such product categories, it's talking about the rulemaking required under paragraph 1. And so it refers back to paragraph 1, where the Commission's authority is to first assess, and this is B1A, the effectiveness of any voluntary consumer product safety standards for durable infant or toddler products. So it's by reference to existing standards. And then in B1B, to then promulgate consumer product safety standards that are the same as such standards or more stringent. And so the timetable provision, paragraph 2, has to be understood only as a reference to B1, which it expressly references. And so the point of B2 was to tell the Commission, and this was a matter of urgency at the time, and I can provide a little more of that context, to go through these voluntary standards that exist methodically and quickly and make them into mandatory standards and make them more stringent if the Commission saw fit. B2 does not create a new power to regulate where there is not a voluntary standard already existing. And the such standard refers back to 1.
Well, the such in B2 refers to the entire category.
Well, it says, oh, sorry, Your Honor.
No, go ahead.
Well, just the such products in the thereafter sentence, thereafter they shall periodically review and revise,
right?
Blah, blah, blah. That it says such products, and that refers possibly back to the first sentence of B2. And then the first sentence of B2 says has promulgated standards for all such product categories. Again, that's by reference to the rulemaking required under paragraph 1. So essentially the second.
Well, but the closest, the nearest antecedent is the clause which references categories later in that sentence, categories of durable infant or toddler products, right? Which is the entirety of what 104 is about.
Well,
not just the little sub areas where there's an existing standard.
No, Your Honor, I think it's important to look at the beginning of the sentence in paragraph B2. So it's not later than 1 year after August 4th, 2008, the commission shall commence the rulemaking required under paragraph 1. So it kind of incorporates by reference B1, which is the authority, and shall promulgate standards for no fewer than 2 categories every 6 months thereafter, beginning with the highest priority until they've promulgated for all such categories. So again, I think it's very clear when the whole paragraph of B2 is read that that's referring back to what is the subject of the rulemaking in B1, and B1 is about existing voluntary standards. And if I may, I think it's really important to take a step back on the context. I think the statutory text is clear when you kind of look at B1 first, the authority, and then look at B2 as the timetable, which is what Congress was saying. But the entire point was, so the CPSA existed since 1972. And under the CPSA, the commission can promulgate mandatory consumer product standards, and in some cases ban products altogether across all products, including durable nursery products. And we talk about this at 5 to 7 in our brief of that process. The key aspect of the CPSA that helps understand Section 104 is that under the CPSA, the general power, the commission may not enact a mandatory standard if there already is a voluntary standard that reduces the risk of injury and for which there's substantial compliance. And so that limited the commission's ability to enact mandatory standards if there was actually a voluntary standard already covering the space. Flash forward to 2008, that's when the CPSIA was enacted. And the genesis of that act, as the government's brief acknowledges, was a bill introduced the prior year trying to make the voluntary standards mandatory to make sure that they were enforceable and strong enough. And so this is, we reproduced Senator Klobuchar's explanation, for example, of the bill at pages 15 to 16 of our reply brief, and that makes clear the purpose. It was not to be filling in gaps where voluntary standards did not exist. It was to strengthen and to make binding existing voluntary standards for durable products. And so it's just simply not the case that Section 104 was meant to fill gaps where there wasn't a voluntary standard. And the government's entire argument is based on the premise that somehow it will be powerless to help to regulate new products if they don't happen to already be subject to a voluntary standard, but that's just not the case. They have that power already under the CPSA. And I think it's very, one thing I would direct the panel to, if they haven't already viewed it, is there's a video of the commission's voting meeting in the administrative record, as well as minutes of that meeting. And I think it became very clear by the end of that meeting, the chairman of the CPSC just found that the CPSA alternative of making rulemaking was too slow for his liking. I think he referred to it as a stampede of turtles through a vat of peanut butter or something like that. And so I think the idea here is that that's rulemaking. And so there was a way to do it. It maybe take longer than they wanted to, but the way to do this was not to take an expedited provision that was a tailored authority meant to transform voluntary to mandatory and say that could be a way to regulate anew. I see my time's, please, Your Honor.
Just speak, I mean, you have really helpfully said, step back and sort of describe the purpose of the legislation and the ability to quickly convert existing voluntary standards, but just stepping maybe even further back and explaining why that would make sense as a congressional objective if what the government argues here is that the standards might be most needed in the area where even getting a voluntary standard off the ground is very contentious. And, so the notion that there has to actually be an affirmative standard as opposed to either a voluntary standard or the voluntary standard effectively being zero makes, it has some coherence as a narrative. And I've heard you, and I've read the legislative snippets in the briefs that there's a narrower project, but it seems like, one has to swallow something that's really pretty counterintuitive in terms of congressional purpose to credit that reading.
No, yes, Your Honor. Thank you for the question. I do think that it's important to see there was a specific problem being targeted, though, in 2008. And it was that there was a series, it actually was also about recalls and making recalls stronger, but the sense that there were these voluntary products out there that were subject to these voluntary standards, and that you essentially could not make a mandatory standard under the CPSA if the industry was kind of going along with that. Congress was not at that time thinking about What do we do if there's not a voluntary standard in this space? And there are other powers. There is the CPSA, of course, and that does take time, just like a lot of rulemaking does. But the CPSC had time to do that here, I think. And I can explain a little more about the specifics of this rulemaking, kind of maybe the agency failure that kind of led to us to the point we're at, where they had to cram this in. But anyway, there's the option there for the Congress gave the powers. There's also the recall power, and there's actually power under Section 12 of the CPSA to go into court and seek an injunction if a product is viewed to be imminently unsafe. And so, and the CPSC has used the recall power at times. There was the Boppy of child product that recently was recalled. And so there are powers available if there's an imminent need to regulate more quickly. But the thing that just was never done in the history of this Section 104, it's been used up to 50 times since this was enacted in 2008, was ever to sweep in a category of products that was not previously subject to a voluntary standard.
So it's curious. I realize this is counterfactual, but what if the commission had started this rulemaking and with reference to the Bassinet standard and just said that is the relevant voluntary standard here, and we think it's the standard that best applies to baby boxes, and our concept is that baby boxes are effectively, basically where they ended up. They're effectively non-compliant bassinets. If they had started the rulemaking with reference to ASTM's bassinet standard and said, we are, just gonna tweak that standard and clarify that it applies to bassinets. It applies to baby boxes. That would resolve your statutory objection or not?
Your Honor, I don't think so. If the voluntary standard literally did not cover, it defined bassinets, or they are currently just defined, and didn't excluded this other set of products. There is a question maybe in some hard cases of what is just the same product but a different variation on it versus what is a different product. I think here the commission is taking the position that this is in fact a different product line. So that's kind of not as squarely presented. And also just looking back through the history of the rulemaking. And I do think that the not just the statutory history, but the genesis of this rule is important. And we start this at page 10 of our opening brief. We talk about the 2013 Bassinet standard and how the commission in that standard itself carved out inclined sleep products as not being part of that standard. So
but not other flat products.
Yeah, at that time, I guess they weren't even really necessarily addressing that issue. It was really more of a carve out of the other inclined.
Right, but in a way, that's what made me start thinking about this, because there wasn't ever a carve out from the Bassinet standard of other flat sleep products. And so I guess I'm sort of still, you're right that the commission is taking the position that this is a distinct product category, but I'm just trying to understand the sort of the nature and scope of your statutory argument going forward, and whether it's just a little bit of an anomaly that it's referred to as not from the beginning as the relevant standard, but really at the end of the day, it is the relevant standard.
Your Honor, there are a set of products. This is, yes, I think I see your point. And I think that the point here is that there have been products that have been generated since 2008 that didn't fall neatly into one of the categories that Congress listed. So this is at the end of 15 USC 2056a without a parentheses. And this is like in our brief, addendum 10 to 11. There's a definition of durable infant or toddler product that's broad, but then also includes several examples: full-size cribs, non-full-size cribs, et cetera.
Right.
And so, you would only have this many standards if those were all the categories, but they keep adding in so that we've had 50 rulemaking is because there are more products than just the kind of broader categories at issue here. And so I think what's important is also very important is that the Bassinet standard in 2013, ASTM actually revised its voluntary standard. It was asked to and did to have the voluntary standard align with what the scope was at the end of the day of the rule that was being issued. And so there's just been this understanding due to the collaborative nature that Congress intended between industry and the commission here, is that every single other time there's been a scope issue at the point of the rulemaking by the commission, they've worked with industry to get the voluntary standard to align with the scope. And so this is the first time that hasn't happened, and that was available to the commission, but it just didn't, was not able to do it, I think here largely because it actually is a distinct product category.
But isn't that happening now? I'm sorry to interrupt.
Oh, no, please.
Isn't that happening now with we got the 28J letters, and I recognize that you thought that was an inappropriate authority to raise in a 28J letter, but it was helpful to me to know that ASTM is coming up with a standard, and would it provide the referent? And I realize, again, it wasn't there at the beginning, but it seems like it might come in lately and provide the voluntary standard for purposes of your statutory theory under 2056A 1B1.
Yes, and I think what's happening here is this is the part of the this is actually falling on. There's a provision of the statute that, to the extent that there's already a voluntary standard that has been approved and is now mandatory, the voluntary standard itself evolves, that the voluntary standards organization needs to alert the commission to that, and then the commission again has a chance to either accept it or make it more stringent. And so what's happening now is the Bassinet standard is being revised somewhat to encompass some, but not all of the products at issue in the current that are banned by the rule. And so, for example, it will not be something that allows in-bed sleepers. That's only
your client is not marketing in-bed sleepers. Your client is marketing baby boxes.
Currently our client is suspended its operations because the rule has put it out of business if it takes effect. Our client does make baby boxes. Our client actually is more broadly interested in beds in the flat infant product market and would like the option to be able to market its baby box as an in-bed sleeper, likely with some modification. And it's, of note, the commission's own letter in December 2019 acknowledged that baby boxes could be in-bed sleepers. So our view is that we have standing to bring a challenge not only as a baby box, but also as potentially an in-bed sleeper, and more broadly as a company that is interested in making innovative flat sleep products, which this again shuts down because it doesn't even just take off the market these dozens of undefined products that are banned, but also anything in the future that would evolve.
You clearly, your client, oh, go ahead, Judge.
No, you go ahead. You finish up.
I was just going to say your client clearly has standing with respect to the baby boxes. But I was a little confused why the briefing focused as much as it did on in-bed sleepers. Is it a non-severability argument that you're making? I mean, you mentioned that it's both because Finnbin is interested in making in-bed sleepers. And if we didn't find that, just for purposes of argument, to be sufficiently imminent to support standing vis-a-vis the in-bed sleepers, I took it the alternative argument was that it was the treatment of in-bed sleepers was illustrative of the arbitrariness of the commission's approach here. And I still wasn't sure how that linked to your client's claim, unless it's some kind of severability argument that if it's irrational or arbitrary with respect to in-bed sleepers and you carve that out, then you can't accept the extension of the Bassinet rule to other flat sleepers like baby boxes. But help me out with understanding why the in-bed sleeper issue takes up as much real estate in your argument as it does.
I think it does illustrate, well, to begin with, the commission dealt with this class of products as a mass of products, right? So they were actually not themselves separating them out and actually discretely looking at each of the products or maybe sub-product lines, if not every single product itself, to actually assess which one of them poses potentially this risk or not. They were lumping them all together. And so that's part of our point. Our entire argument is that baby boxes and in-bed sleepers and baby tents and all these other products were all lumped together by the commission and not analyzed separately. And that type of one-size-fits-all rulemaking, for the reasons we describe in our brief, is not appropriate. I think there also is a severability issue. I think, for example, the commission cites cases like North Carolina versus FERC, but those cases make clear that the commission's order, where it's a unitary one, is not subject to being severed. And so here, our view is that the commission treated all these and lumped together as one product class. We object to that. We actually, Finnbin does, and again, I would direct the court also to the portion of there's a December 2019 letter from the commission itself acknowledging that baby boxes can be used as in-bed sleepers. And so I think Finnbin sees it standing as both being a manufacturer of baby boxes, its primary product. It also sees itself as someone who could have their baby boxes used as in-bed sleepers if they were permitted to market them as such. And they also would like to be able to make other flat sleep products in the future. They're an innovative company. But on the other hand, the main point of our argument was both that it affects us, it shows the rationality of the entire rule, the way they did it, and it is not severable because the commission treated it all as one big blob of products.
Can you explain to me one thing just about how baby boxes are used? Are they meant to be put on the floor, on beds? Like it's because it's not great. I don't know whether it's dangerous on the floor because someone will step or trip over it, but obviously the commission doesn't want things on beds. I just don't know how they're envisioned to be used as sleepers.
Thank you, Your Honor. I think that they are like any kind of baby product, subject to sort of the care of the parent. But I think the idea is to provide a clean and sleeping place, often for people that are not in a environment where there's a lot of, other amenities or furniture or things like that. Like there's been a reason that these products have been ones that have been used by state and local governments and times to be a kind of an aid to a new family to have a safe, clean place to sleep, either on the floor or some other stable surface where the baby can actually be safe and enclosed. And so I think that's the idea. And I think, like I said, that Finnbin would want the opportunity to market itself as an in-bed sleeper, but that's even another hurdle to climb given what they're kind of dealing with at the commission. So at this point, that their first and foremost use is to be on a flat surface to be able to give the baby a clean and flat place. And again, the commission's whole point is, and the kind of throughout the administrative record, you see back is best, flat is best. And as the, Commissioner Biacco said at the final voting meeting, she's having a hard time understanding how if flat is best and back is best, we would then bar, as a matter of law, all of these flat sleep products that people have used to ensure the safety of their infant, often in situations where there's not other amenities available to make it even more comfortable, such as a full-size crib or other things like that.
On your website, your client's website, they describe their product as a baby box bassinet. And the other, at least rigid flat sleepers that are covered by this rule are also called either compact or portable bassinets. And so just following up on Judge Pillard's point, if they had started with the bassinet voluntary, or the bassinet's now mandatory standard, started as a voluntary standard, so meets your statutory concern, and simply said we're amending the definition to include all products marketed as bassinets or that are flat sleepers, rigid sided, some way that would encompass baby boxes. Would you have had your statutory objection?
Your Honor, I guess I'd have to, the specifics would matter, but I think yes, to the extent that the scope that the products covered by the voluntary standard, there was a delta between that and what the CPSC's ultimate standard is. And I think that is just, and I can go through the kind of the history of the rulemakings.
Was there an express carve out of other rigid sided, firm sided, however you want to describe it, flat sleepers from the definition of bassinet, or is that simply what they conceptualized at the time?
The main carve out at the time was the, it was supposed to have
not incline, you're talking incline, yeah.
Right. Yeah.
I want to talk about incline. There was no express carve out of other forms of flat sleepers, particularly those that marketed themselves as bassinets.
Yes, Your Honor, in rebuttal too, I'll make sure I have that the site for you from the bassinet rule, because I do think it's important that the commission itself has recognized this as a separate product class, and this why it actually carved it out from the bassinet standard. It's why it was working on the standard for some time.
Can you clarify from what you mean by this? Is this whole group here that you say they sort of shouldn't have grouped together to begin with of unregulated other sleepers, or is the flat sleepers, firm-sided flat sleepers?
That's a fair question, Your Honor. I think it's both. You're right. The 2013 Bassinet standard carved out the inclined sleepers because that was the issue at the time. The in-bed and these other flat products all were emerging as well. And so what happened is now at the ASTM level, there was both an effort to make an inclined sleep standard and an in-bed sleeper standard. So there were two separate subsets coming out of that. And what happened was so then the inclined sleeper progressed. The agency did the 2017 NPR. It never completed that process. It then had some additional issues with the rock and play come up and kind of redoubled their effort in 2019 do inclined. At that point, they actually kind of didn't even very clearly in the rule itself, the 2019 NPR explained that flat products were in. It was only by a few words here and there. And it was not really until the December 2019 letter from the staff to the ASTM that it really became clear to industry that, oh, wait, this is not just about making the inclined sleep product more exacting. This is actually going to sweep in everything. And that's when you started getting the flood of comments from industry. But just to be very clear to answer your question from the industry's perspective, and I think it was that there's a Bassinet and the commission's perspective, the carve out was the inclined. And then this emerging in-bed sleeper was coming, which the commission was participating in that standard setting process. And then it got to the end of the day at this rule. And frankly, out of a sense of, again, perceived urgency and worry about having another rock and play issue from both a PR perspective and, obviously an infant health perspective, just swept it all in here. But there were other powers available to it were to really find these products to be an imminent threat. And I guess our point is
just to be clear, if I could just, please, sorry, finish your sentence. Go ahead.
Oh, no, please.
If I could just clarify, your client prior to this time did not market its baby box bassinets as in-bed sleepers, correct? You say it may want to in the future, maybe with some modifications, but as of the time this petition for review was filed, your client had not marketed baby box bassinets as in-bed sleepers.
I think I will confirm that. Again, let me just make sure I get that to you. But I think that the point is that that would just be another hurdle for them to have climbed at the time. At this point, they're just trying to get a product that they would like to be able to do that. They believe that their product potentially as modified would be an appropriate in-bed sleeper.
Sure, I'm talking about at the time. Though.
Yeah, no. And part of the reason why was because the in-bed sleeper just added another issue. What they're trying to do is fit in some standard that they can fit in, but this is not made up here. They would actually like to have their product used by as many people possible because they really believe in their product. And to the extent that there are bed sharing parents that would prefer to have a modified version of this to be an in-bed sleeper or even use it as is, they would like that. So, but you're right. Yes, the main marketing of the product was as a baby box, not as an in-bed sleeper again, because that just raises additional issues. Would they like to be able to do that tomorrow if they could do it? Yes, they do, because that's they want their product to be used as widely as possible due to its unblemished safety history and over 80 years, as we point out in our brief.
Can I just one thing I just wanted to clarify? It sounds like this is true, but I just want to confirm because we always have to make certain on standing. Your clients have suspended their operations, even though the effective date of this rule has not yet kicked in. And you use the word suspended in your standing description. Does that mean that if you were to prevail and either the rule as a whole or as applied to baby boxes were to be overturned, that your client would intend to resume operations?
Yes, Your Honor, that's correct.
I just wanted to clarify.
Yeah, there's like a production chain lag. And so I think the last thing they wanted to do was create a production chain that they couldn't satisfy. So that's the issue there.
Okay. And I just have one other question. I know it's not so we'll take as given it's not what the agency did in this case, but they've been talking here about, the more stringent clause, but the one before it that says voluntary standards that are substantially the same. If they were to amend the definition of bassinet and the existing bassinet safety standard in a way that included all flat sleepers with firm or rigid sides, would that qualify as implementing the standard in a way that is substantially the same?
Your Honor, would it still need a stand?
Would it? No, I told you, all they do, no.
But no.
I'm sorry. No, it would include, as we're needing a stand, things that don't already have a stand. So it would cover baby boxes and these portable or compact bassinets. So they would keep they would say in their definition that, I know they define bassinets now as having a stand, but they would say, maybe they would add in a whole new clause that we say that, this bassinets are defined as flat sleepers, the 10, less than 10 on incline, firm, rigid sided. And then it would say to qualify as a lawful bassinet, you would have to have the stand. But they would start off from saying what we mean by bassinets that are covered, that are subject to this standard, define that in a way that would include baby boxes. Would that be substantially the same? I don't know. I'm just curious as to what substantially the same was, and no one was talking about it here. And I realize it's not what they've invoked.
No, I understand what you're saying. This is in the, just in B1A, sorry, just the B1A, but B1B1. Yes,
Yes,
B1,
there you go.
B1. Yeah, I think substantially the same has essentially been, it means the same. I mean, I think that may be a more stringency. I guess that's, right. It's not more stringent.
That sounds more like, right. It's not stringency. That's addressed in the next provision. So I was really trying to, and I don't, maybe there haven't been any cases of it. I was trying to understand what leash is given to the agency by the substantially the same, like where can it move in that area?
I think very little, frankly. I mean, I think the way it's actually
but maybe very little, but in what way? You can't refer to stringency because then it would be redundant. So it must refer, I don't know whether that refers to scope as opposed to stringency, or maybe there's another category of things.
I'll take that back too and try to give an example if I can from the 50 prior rulemakings, but I think it would be something like, say the standard was in inches and it was going to be expressed in centimeters and there was a slight difference in that or something like that. I think the way it's been understood is substantially the same means, to the extent there's a minor wording issue or something like that, to kind of describe the same concept and have it be substantially the same in
so it's sort of
effect.
de minimis changes.
That's my understanding, but I will look back through the list to make sure I'm not misrepresenting that.
It's not the one that's at issue in this case, so I'm cold calling you on that one. So.
No, it's fair enough. And I just think it's important here. This is not this is just an important power. Obviously, infant safety is important. Our client believes in that. But this is just a situation where things went haywire at the commission after 50 times of doing it, or almost 50 times of doing it the right way. And so, the right thing to do here is to go back and try to do this the right way, either through a voluntary standard, through the use of its other powers, or making rules under the CPSA, which again is just something agencies have to do. And I think the Section 104 power, while convenient, was never intended to be a tool for going around and banning wide swaths of products without the type of cost benefit analysis that the commission usually is subject to when it's not operating under Section 104. And so thank you for your consideration. And we respectfully submit that the rule should be vacated with respect to previously unregulated flat sleep products.
Ms. Hartnett, just on the ASTM Bassinet standard, we don't actually have the text of how the voluntary standard defines a bassinet in our record, do we? It's behind a paywall. It's not in this Federal Register.
I know that that's an issue that some actually were raised in the comments. The final rule in the joint appendix does explain how it is different from the scope. So that's part of its obligation when they do the 104 is to kind of go through and explain this is the voluntary standard and this is how it's different. And so there is a part of the final rule that kind of walks through all the delta between and just candidly, agrees that it's broader in scope than the Bassinet standard, in addition to lots of other ways in which it's different.
Yeah, it is in the JA.
And I believe that there's also we also did put in 2 ASTM standards. So there's the Bassinet standard. There's JA 789 is the bassinets and cradle one. And then JA 805 is the incline one.
Right. I think it's also reproduced in this federal regulation. I swear I read it in there too. So in this very federal regulation, don't they reproduce it in there?
Yeah, and I want to make sure what they have to do is actually explain the delta between what they're doing and what the voluntary standard is. So what they actually were doing was going through and saying, oh, this is how the inclined sleeper standard is not going to be like what we're doing because we're going to be just imposing the Bassinet standard. So the way that the commission kind of lays out what it's doing to the voluntary standard that it's reviewing kind of shows you how it's doing the delta there. Yeah, exactly.
Thank you very much. And go ahead, Greg. Judge Katsas.
A couple, one or two more quick ones. We've been talking a lot about the level of generality at which the commission must act. And you have a sort of intuitive idea that it's at a pretty low level. We're talking about bassinets being different from cribs, being different from baby boxes, being different from inbred sleepers. But what in the statute prohibits the agency from ratcheting up the level of generality a little bit and just saying, okay, we think the relevant product is infant sleep products?
I think what prohibits that is the reference to the voluntary standards as the baseline for what it has to do. And so again, just kind of taking that, I think that the issue is, and the reason why there have ended up being 50 of these is because as time has evolved since 2008, it's not just that neat list that's in the statute. It's become more complicated, and there have been subsets of product lines that have their own needs. And so I think just understanding this truly is something that is like the voluntary process is churning things out. And then the CPSC is going to look at it to decide, is this enough or do we need more? That's what's going on here.
I mean, this may be another way of expressing the question that Judge Pillard and Judge Millett have already asked you. But if the commission starts with infant sleep products as the relevant product/unit of inquiry, they're going to create overlap with existing standards, including the one for bassinets, no?
To date, they've managed to do this where, I mean, they sometimes note in their rulemakings of like how it does or doesn't dovetail with a different one. So for example, if you're not using the bassinet that in a stand position, for example, like that rule said that you're not going to be a bassinet. If it's something where you can remove the thing and put it separately, then you're not a bassinet anymore. So I think the commission is mindful when it's doing these things of explaining kind of to the extent there's overlap with another standard, arguably, which one applies. But I think the key to your point there is, Your Honor, yes, they could actually decide infant sleep was the right level of generality. But what they would have to do then is work with the ASTM to ensure that that was overlapping with an existing voluntary standard. And then that would be what gives them the power under 104. And otherwise,
fully overlapping in your view in scope. It has to be coterminous in scope with an ASTM standard in order for the commission to regulate under section 104.
Yes, it does. And that's been the commission's understanding of its own authority through not just the legislative history. I cited not just the text, but our reply brief at 17 to 18, for example, discusses recent CPSC reports to Congress and years of their strategic plan where they describe their authority exactly that way, which is that we take the scope of the standard and we then we decide whether to take it or make it more stringent. And so that's been their unbroken practice. That's truly been what they've done every single time. And every time to date that they've had a scope difference, even relatively minor one, ASTM and them have worked out together how to have the two standards align. And that's because everyone understood until this rulemaking that the way section 104 worked was to track off of what the voluntary standard was and to make it mandatory.
So that puts a huge amount of pressure on the distinction you want to draw between stringency and scope, right? So, I mean, why wouldn't we think of stringency? I'll pick a synonym, just, intensity, right? It's a vertical concept. You have a regulation that applies to some set of things, and you make the regulation more onerous, but only with respect to that set of things, as opposed to scope, right? You expand the regulation to other kinds of things. Why might stringent not be at least ambiguous on which of those two dimensions the agency can act on?
Thank you, Your Honor. I think in our brief, we tried our best to do that textual analysis. We looked at the definition, we used strictness, and the government really didn't have a response to that. I think it's also very important to just, so even if there's possibly some ambiguity in that, let's look to what Congress used it twice else in the same CPSIA as section 104. And I think it's really telling how it used that term. We talk about this in our brief at page 31, when they were talking about making a more stringent lead paint ban, which was a different part of the CPSIA. There they were talking about moving from a 0.06% to a 0.009% lead content, right? So that just kind of gives you a sense of this is about calibration, not scope.
But lead is an easy case for that, right? Because lead is the danger, whereas here the dangers are myriad. They're being stepped on, falling off a surface, being inclined, folding over, turning, so.
No, I appreciate there could be harder. That's the easy case probably for what stringency is, like ratcheting it up a 0.00 whatever. But I also would direct you to 15 USC 2056B, which was section 106 of the CPSIA. At the same time that the Congress was doing this with the durable nursery products, they were also saying with the toy standards, look at the existing voluntary standards and you either take them or make them more strict, more stringent. And so again, I really would commend, and you may already have, of course, done this, is to look at the CPSIA, and this is in like the House reports we cite and otherwise, to just see what the provisions of that act were, because this wasn't coming in and saying, fill gaps or create regulation anew in different areas. This was all about finding this problematic system where the voluntary standards out there were just not cutting it because they were not enforceable. And the Congress wanted to give the commission a power with respect to durable nursery products and with respect to toys to not have to just rely on the industry where there was a voluntary standard. And that's really what's going on here. So stringent, I think when we look at what this Congress was doing in the CPSIA, becomes very clear that they weren't talking about opening up new areas of regulation, particularly given that the agency already had that power. And that wasn't the problem that was before Congress in 2008.
Okay, thank you.
Why the government's one of its responses is going from no regulation to regulation is a vertical increase in stringency. Nothing to something is more stringent. And so they were, again, kind of doing things in reverse order from what happened here. If we start with the Bassinet standard, and we say, wow, the standard, because of its definition that it includes this base or stand, has left these things at zero level of regulation. And so we need to change the Bassinet standard, at least for things that call themselves bassinets, like baby boxes or compact or portable bassinets. We need to fix that. We need to repair that so that they are subject to the same stringency of regulation as other types of bassinets, i.e. those that have stands already. That would count. You might have other objections, but that would count as a change in stringency, would it not?
I mean, the examples of we put this in 30 to 31 of our brief, but examples of like more stringent would be like, there was one example of the carriage stroller rule where they wanted to have the testing about the risk for the head possibly getting trapped as being a stronger testing mechanism. And then we also
but as to my question, I saw the examples. I'm asking mine where they say, wow, there's these things that are marketed as bassinets. They're flat sleepers, they're rigid sided, just like bassinets, but because of our definition, the stringency of their regulation is zero at this point. And we want to move it up to the same level as bassinets that have stands. And so if that's what they do, is that simply an increase in stringency of regulation from zero to the same as all other bassinets?
No, it's not, Your Honor. And it is because the way that the standard is written, it needs to track the voluntary standard. And so that just is how this statutory scheme is written. And that is something that the industry views as a separate product category. That's something until the final part of this rule where they swept this in here was viewed as a separate product category. And I think it's important. You've noted that like the potential marketing as a bassinet and that these other products are called compact bassinets. That's a different, I mean, that's a word bassinet. That's not the technical, there's a technical definition of it and there's common parlance here. And so to the extent that
that's one of the things the agency said it was concerned about here is that as to some of these products, not all of them for sure, they're marketed as bassinets and they're worried about consumer confusion. Maybe consumers assuming that they have the same safety protocols as other bassinets. That's certainly a legitimate thing for the commission to address.
I would say, if anything, it's limiting the rule in the first place to the having a bassinet have to have a stand. That's more of a potentially counterintuitive thing than having a thing that's a solid-sided box or other container to actually be called a bassinet. And the compact bassinets, as you know, or may know, are like soft-sided and can be transferred with people to help protect the safety of their infant. And again, I think that
I'm just asking whether that change, as I've described it, which feels to me like a vertical change as opposed to the horizontal scope change, from zero to the same as other things marketed as bassinets, why that wouldn't count as an increase in stringency. And you're saying because it's not what the voluntary standard already covers, but of course stringency allows you to change the stringency of a voluntary standard. So I think
it's because it has a different intent and purpose. I mean, I do think there could be some. I mean, I think here that the fact that the industry itself has kind of seen this as a different product set, and until this rule that was recognized as that makes a difference, that they're the kind of stand bassinets and that there are other in bed or sleep products or things that are like, I guess it's more accurate to call them like standless sleep products. But I think it just really is a different intent.
Well, they've had the bassinet standard and the statute obligates them to go back at periodically and review and make sure existing standards are providing the highest level of safety feasible. So if they've gone back to their bassinet standard, and I know they took the most circuitous route possible here, but if effectively what they did was go back to their bassinet standard, and at least as to your client's product, say, wow, it's not providing the best, the highest standard of safety feasible for this category of things that we're going to call flatbed, firm-sided sleepers. We need to fix it because this component that defines Bassinet as having a stand already has resulted in this proliferation of products that serve sort of the same function as a bassinet, but aren't riding the same safety level. And so we need to fix that. If they had done it that expressly in that terms and had changed the definition of bassinet to encompass your products and then still required the stand as a safety requirement, that would have just been an increase in stringency, would it not?
Your Honor, no, I don't believe it would be. It really is a different product use in case. I mean, the baby box, you could be lying on the floor and reaching your arm over and touching the baby if you don't have a sleep, depending on your sleep situation. There are many reasons why in the in-bed sleepers present their whole other range of things, which is actually to try to take the reality of bed sharing and to make it more safe. No, I
understand your arguments about that and your clients, what you say are your clients' future intentions. I really just wanted to focus on these baby box bassinets for this purpose.
Yeah, well, in that case, I do think that would not be an increase in stringency. That's certainly not how stringency has been understood in the application of this rule to date. That would be taking a product that would be a different product that could be used in a different way and actually shoehorning it into the standard. And every time that there's been some change in scope like that to date, the commission has worked with the voluntary standards organization either to cut that product out and wait for that voluntary standard to emerge and then regulate that, or to conform the standard. And that didn't happen here. And that is what Section 104 requires. It's really critical that the agencies be held to, I mean, here, this is an obviously important area of infant sleep. No one wants infants to be harmed, but the type of analysis they did was a very much a shortcut than what they would have had to do were they trying to ban these products through the banning authority or for regulating them anew. And so I think that the question here, obviously the commission didn't do what you were suggesting, and that would have presented a different question, maybe allowed for more comment and deliberation. But what they did here was instead essentially kind of panic and try to put in products that didn't get a full, didn't get fully through the voluntary process, and they weren't the subject of the type of regulation that normally is required if they're regulating anew. And so it's in that situation, I think that's why stringency did not mean to create this new power for the CPSC. That was not the problem that was being solved for in 2008. And that is one that they could have, if they just did this from the beginning the right way, they could have done this through their normal powers under the CPSA.
So can I then also ask, I just want to make sure, because I think this is what you said to Judge Katsas. So in defining what is a relevant product category, that has to start with the voluntary organizations. The commission itself can't say, here's what we think the relevant product category is, and define that relevant product category?
Under Section 104, I think that is, Congress provided for several product categories in the list at the end of 2056A. But then because B1 makes clear that it's by reference to existing voluntary standards, that is true. I do. Yes, I think, and it's really not a limitation here. It's actually just the problem that was being solved for.
This only includes, because it includes, I think everyone has recognized that the commission can add to that list, but you're saying they can only do so to the extent voluntary organizations start the process first.
Under 104, and that's what's happened.
I'm only talking about 104 here.
Yes, correct, Your Honor. And
what would happen then if you had a new product category and it was deathly hazardous? We'll just call it new category of sleep product X, because I don't want to suggest it for any of the existing ones. And it just, kids are dying and getting injured, babies are right and left. But because they contribute enormous amounts of money, this company does, to all the voluntary organizations and have enormous pull within them, no voluntary standard ever starts. And I think your position is that then the CPSC would have to go through its ordinary, lengthy, slow regulatory process. Is that correct? To be able to regulate that product.
That's one of their options. And it's not that, it is lengthy and slow like many rulemakings are, but no more than actually what occurred here if they had just done that Just to be clear, this is taken since 2019. There's also 15 USC 2061, that's section 12 of the CPSA, that allows the commission to go in and get an injunction against imminent and unreasonable products that pose an imminent and unreasonable risk of death. There's section 15.
Can it define under that provision, to go get the injunction provision, can it define the category there, even if it hasn't been defined yet by voluntary organizations? There, it could define the product category that it needs to enjoy.
Right. Yes, because of the showing that needs to be made.
Can't define the product category here under.
And I would also, the recall power, 15 USC 2064, the recall power section 15, again, that is where they can go in and do a recall if there's a substantial risk of injury. Yes, that's true.
In both of those, they can define the product category. They just can't do it here under section 104.
That's correct, because the problem that Congress was solving for in 2008 was truly to make voluntary standards mandatory.
I understand that.
Yeah.
The voluntary standards argument is it seems to be distinct from defining product categories, though, but you're saying it's one and the same for purposes of 104, but it's not one and the same for purposes of these other provisions, emergency provisions, or even for just general rulemaking under the 205. Is it 2056 without the A on it? Is that the general rulemaking one?
Yeah, it's 2056 without the A. Yeah, Your Honor, the answer is just yes. And I think it's just not anomalous. It's that the background thing is that when you want to regulate something, take it off the market, ban it, you have to make a certain level of a showing. And if you don't want to do that, and you're actually just trying to transform something that's already been agreed to into mandatory, potentially by increasing the stringency, again, by putting on a larger warning label or making the testing regime stronger. Those are things that have been the examples in the past of making it more stringent. Those are things where you can go through 104 and it can be faster. And it can actually be faster in 2061 or 2064 if you actually have the showing. Here, there's just not that showing available to them. And that's why I think that they deliberately chose to use this as kind of a backdoor to get in this regulation when there are other ways that they could have done it. And that's just the reality of what happened here.
I hate to ask another question.
Oh, no.
To so long.
So,
I just have one more question, which is, am I right that before this rulemaking that ASTM had considered a voluntary standard for baby boxes, but just hadn't arrived at one?
I believe right? They were in the process of constructing kind of a standard for in-bed sleepers and for
but not baby boxes.
I believe that would have been able to be swept into that standard itself, the in-bed sleeper.
Right, but at least your client wasn't marketing its baby boxes as in-bed sleepers. So, but there wasn't any separate undertaking by ASTM for baby boxes or for non-bassinets with no stands.
There's the compact bassinet effort, I think, that was it's kind of both related to, it's partially related to this amendment of the mandatory rule that was brought to your attention right now. So that not to overly complicate things, but there really are different. There's the bassinet as the commission has kind of defined it, meaning something with a stand, which also tracks the voluntary standards. There's the in-bed sleepers, which can be overlapping, but also
there's the compact bassinet. I guess I'm thinking about the compact bassinet and wondering, under your view, if a voluntary standards agency disavowed an intent, said, look at these compact bassinets, not a problem. We're not going to come up with any standard because we just think there's just no danger that can come from them. It's a cardboard box. Then that would be the zero standard, in your view, that would enable the commission to regulate from zero, but only if there was some kind of affirmative disavowal of an intent to come up with a substantive standard or requirement.
Yeah, I don't even know if there has to be an affirmative disavowal. There just has to be one that doesn't exist. And so it would be within the commission's right to, like, even if it just looked at the landscape and said, there's not a voluntary standard here, you guys are dawdling, we need to make a standard. They have that power available. And if it's something that's at a risk of, something at a recall risk.
Who's the they in your sense? ASTM has the ability to make a standard, not the commission. The commission can't make a voluntary standard, can it? The
commission can make a rule that would cover, like the magnets is a good example of this. There's the magnets case where kind of also was vacated for sort of different reasons, but also arbitrary and capricious reasons that are similar here. But basically, taking a step back, the commission can make its own standard by using its normal rulemaking powers. So the commission is not powerless to make a
normal rulemaking
standard.
Powers. I'm talking about under Section 104.
Oh, sorry. No, yes.
I'm talking about under Section 104. In your view, if a voluntary standard setting organization looked at a subcategory and said, okay, we think of this as a distinct subcategory, and we think that there's no need for a voluntary standard here. So they've touched it. They've done the consultation that in your view, is encouraged by Section 104, but they've decided that the standard is 0. They haven't actually published anything, but they've just, and in a way, that's not far from what's happened here with compact bassinets, right? I mean, before the latest development in the 28J letters. I'm just trying to understand, poke a little bit more at the idea that Judge Millett's questioning was asking about, which is, why isn't this more stringent than a 0 standard, especially given that ASTM was somewhat active in this area at the time this rule was promulgated?
Yeah, I think it's the more stringent, to try to answer both those related points, the more stringent, it's the way it works is more stringent than the voluntary standard. And so it kind of presumes there is one. There is this, that was the whole idea here, was that we're going to take ones that are there and assess them. I think in the case that you're describing, if there's 0 voluntary standard, then it's not like actually making a 0 more stringent. The idea there is that you're not having a problem with a voluntary standard that's going to impede your normal rulemaking.
Well, you're having a problem with the voluntary standard setting organizations' lack of stringency with respect to a product subcategory.
In that case, Your Honor, respectfully, I would say that would be a problem with a standard setting organization sort of not either getting it together to make the standard quickly enough, or just deciding to try to, have some space be absent of any standard. And there's just not the problem that created Section 104 in the first place. There, the commission can go make the rule and not have to worry about it getting thwarted, because part of the whole process of the normal CPSA, they have to answer that question before they can pass that rule. Is there a voluntary standard here covering the space? They would easily be able to check that box. And then they could, the industry wouldn't want this, right? They could actually just be subject to a mandatory standard by the commission that doesn't track what they would otherwise have done if they had gotten their act together. And so I think in the hypo,
mandatory standard by the commission under its background rulemaking powers.
Correct. Yeah. So there's an incentive.
There's just an anomaly with, and I don't want to be argumentative with you.
Oh no, please.
To the extent that the commission did ask ASTM, can we remove inclined in the voluntary standard precisely so that the voluntary standard would match what we're doing in this rule, and ASTM was unwilling to do that.
But I think it's really important to look, that's just a completely different scope. The prior examples of that were ones of cooperative, trying to figure out let's do some tweaking here to make sure that we're not there's one part of a product that's not cut in. This was really a change in scope and direction for the voluntary standard. And so it is what it is, right? In the sense that now if there's not a voluntary standard on point, that leaves the industry vulnerable to the commission coming in to regulate. But this was not a situation of from my understanding, at least looking through the record, and I think it's pretty clear, of the ASTM unreasonably trying to deal. They just objected to, on principle, trying to sweep in a new product category where they believe that there were actually just important, that there was already a standard for that product being developed, and that the right way to do it would have been to either confront that voluntary standard once it emerged. But the ultimate thing at the end of the day here was a ban. It was a ban of these products. And I think that the commission, the voluntary organization, was unwilling to say, sure, insert me into your rule and have us banned. That wasn't really what the point was. The point was to find a way to make these products something that are safer. And that is just
to ban products that aren't. Is your ban argument that because there is explicit ban authority elsewhere in the statute, that it cannot, the operation of a rule under Section 104 cannot be to ban a product? I'm having a little bit of trouble understanding what role ban plays in your view, in your argument. I saw it in your brief, but.
Yeah, I think the main problem for the class of products that we're talking about here is that there is not a voluntary, that they were not within the scope of the voluntary standard. I think the ban, to my mind, is more part of our arbitrary and capricious argument, that even if you're going to actually look at these products here, you might want to, you're overlooking the fact that bed sharing is a reality and that these are actually making things safer. And so I think that's just really critical and important, that these are products, and I know we were talking about our box, but if there is an issue of standing too, we would respectfully request the ability to put in a declaration or something on that point, because I think there really is an important aspect of the issue here. We also have other, another, like the Juvenile Products Manufacturers Association, I know would stand ready to become involved in this lawsuit, because we're past the 60 days of the initial suit if there ends up being a standing issue that comes up late in the day. So I think there's just a desire to get a resolution on this question. But I do think that what's important here is that, there was an ability for this to have been done the right way. At the end of the day, this ended up coming in at the end. I really recommend to you the voting meeting to kind of see an example of essentially an agency kind of gone wrong here at the end. And I think the answer is to quickly try to get this back on track so that we can have voluntary standards, have mandatory standards, so that infants can be safe, but that large swaths of products are not being taken off the market, which is not at all what Congress intended when it enacted Section 104 in 2008.
Okay, My colleagues have any further questions?
So,
Okay, so Ms. Hartnett, we've kept you up a little bit beyond
I
your
have-
allotted times, but if you're still willing to talk to us more, we'll give you some time.
Sincerely appreciate the opportunity and thank you.
Okay.
Good morning, Your Honor. May it please the court. Daniel Winnick for the Consumer Product Safety Commission. To the extent Finnbin's statutory authority argument was presented to the agency, it fails on the merits. And that's true both because it's inconsistent with the text and the purposes of the statute, and because the agency's contrary conclusion is entitled to Chevron deference. What the commission...
Before you dive in too deep to your argument there, can I just ask you do you have any update on this ASTM standard? What is the time frame for the government, for them? I guess they have to publish it in some form, and then the government responds. I don't even know what the normal time frames is or time frames are, or whether there's anything more particularly you can tell us about this case.
Yeah, I don't have an update from what was said in the letter. So the process is they have to publish the standard, and then separately they have to provide a formal notice to the commission that the standard has been published.
How long does that usually take after?
I don't know how long it happens after publication. I don't think very long. Last I heard and I think what we said in the letter is that the commission believed that the publication and the notice could happen as soon as the month of March. It's possible it takes longer. There's some ongoing process to continue sort of, I think, tweaking the standard, even though it has been approved. Once the notice
is that right? So right, this is a black box process for me as far as I can tell. So we're pre-commission at this point. We're just within ASTM, and after it's approved as standard, it still takes them a month or so to publish it. Is that pretty normal?
It is at least partly a black box process to me as well. But what I understand to be the case is that the members of the committee have, sort of voted to approve this standard, but the actual text is still being revised, and that's sort of an ongoing and collaborative process. It surprises me that it takes as long as it has as well. So our understanding is as early as sometime this month, it could be published and notice could be given to the commission. Once notice is given, that starts a 90-day window under the statute for the commission either to do nothing, in which case the standard takes effect as a revised version of the commission's mandatory Bassinet standard 180 days after the notice is given, or the commission can affirmatively disapprove the new standard, in which case nothing happens to the mandatory Bassinet standard, and we all go onward. But so those are all clocks that are triggered once notice is formally given to the commission.
Have you have you seen the content of this ASTM, or you've just been told that there's something out there?
I haven't laid eyes on the content.
I don't mean you personally. Has the commission seen it at this stage or not?
The commission has seen it. Yes.
Does
the
it apply to baby boxes?
The compact bassinet standard, yes, it does apply to baby boxes. And in fact, there are already additional proposals to modify even the modified version of the standard to add some sort of particular requirements for baby boxes having to do with, I think, the lid or the waterproofing or something like that. So these are all ongoing processes. But yes, it would, if it were adopted as a revised version of the commission's mandatory bassinet standard, would certainly cover baby boxes. Happy to address anything further on that. Otherwise,
well, if you said, the agency, the commission could say, we like it or we don't, excuse me. But I assume at that point they could say, well, we like it as a start, but it needs to be more stringent. And that stringency would be, for example, this rulemaking. That this is the increase in stringency that we would want over that ASTM standard.
Yeah, so what the statute provides is that they are to determine whether the proposed revision does or does not improve the safety of the consumer product covered by the standard. That's sort of as a formal matter, the determination that they make. So this is getting pretty speculative. I suspect that if the commission regarded the ASTM's revised version of the Bassinet standard as sort of insufficiently protective vis-a-vis what the commission has already adopted, this infant sleep products rule.
Well, that's my question. What is the baseline to which you're comparing the voluntary standard to decide whether it's more protective. Is it more protective than existing federal regulation, or is it whether it's more protective than existing voluntary standards? At which point it would definitely, if it does anything, it would be more protective than existing voluntary standards, because there was no voluntary standard before.
Yeah,
I don't. We have to embrace it as its own. I'm not suggesting that. I'm just that first comparison. Is it's to existing federal regulation or to existing voluntary standards?
I don't think the statute specifies that, Your Honor, and I don't want to get ahead of any view the commission might take on that legal question. I mean, I think in substance,
so that hasn't been clear. It's not clear. Okay.
I don't think it's clear from the statute. I think in substance, the inquiry provided by the statute is that the commission is to decide, whether it thinks what ASTM has done is an improvement or whether it doesn't.
Yeah, it's an improvement over what is the baseline
understood, Your Honor. I don't think the statute is crystal clear on that.
Okay, you're not aware of the commission's view on that.
I'm not aware of the commission's view on that. No.
All right, I won't ask you to go out on a limb on anything else with that.
I appreciate it, Your Honor. So Finnbin's statutory authority argument, again, to the extent it was presented to the agency at all, is inconsistent with the text and the purpose of the statute. And
it doesn't matter that they didn't present it to the agency, right? I mean, our case law, I didn't hear you see you grappling with this in your brief. Our case law is pretty clear when the agency itself squarely, and in this regulation repeatedly, addressed its authority in this regard to regulate. And it was a necessary predicate of their decision that we can review it, right?
So we certainly don't disagree that if the agency considers the exact same argument, that satisfies the requirements. I don't think that what the agency considered here was the exact same argument. The comments that were raised were separate, but I'm
sorry, go ahead.
No, I was just going to say, I acknowledge they were quite closely related, and I'm happy not to dwell on the issue.
Do you disagree that it was a necessary predicate of their decision here to have made this determination that they could do something here that they really hadn't done before?
So it was certainly a necessary predicate that they had statutory authority. I think, as Korotov says, agencies don't have the obligation to anticipate every possible argument that might be made against their statutory authority. But we certainly agree that what the commission said on this issue, sort of roundly rejected the argument Finnbin is making, and that's why the commission is entitled to Chevron deference on this issue to the extent the text and the purpose of the statute are not already clear in the commission's favor. So the text, starting with subsection B1, directs the commission to examine and assess the effectiveness of, quote, any voluntary consumer product safety standards, plural, for durable infant and toddler products, and then to promulgate consumer product safety standards, again, plural, that are either substantially the same as such voluntary standards or more stringent than such voluntary standards. And that language describes a regulatory project spanning the whole group of durable infant or toddler products. Congress didn't say for each product covered by a voluntary standard, determine whether to mandate it or make it more stringent. It said, look across the whole set of products, assess the set of any voluntary standards that may exist, and put in place mandatory standards that are either the same as or more stringent than the voluntary ones.
Don't you think?
Go ahead.
I mean, you have some other features of the statute that cut in your favor, including B2, but just within B1, don't you think the more natural reading of stringent is the vertical meaning we've been talking about as opposed to the horizontal meaning, right? Make the standard tougher for the products to which it applies, as opposed to extend the standard to other products?
So I think that could be true in isolation, but 2 points. One is that it's perfectly natural to read more stringent as applying here, in the sense that what the commission has done is to impose a mandatory standard where there was none. That is a more stringent standard. And again, as Your Honor noted, to the extent there's any doubt about how to understand that language in subsection B1, I think it's resolved by subsection B2, which in the clearest possible terms directs the commission to promulgate mandatory standards for, quote, all categories of durable infant or toddler products. It's also, by the way, bolstered by subsection B4A, which says that when the commission promulgates a consumer product safety standard under this subsection that is based in whole or in part on a voluntary standard, the commission shall notify the organization and so on. And there would be no need for that clause when it promulgates a mandatory standard based on a voluntary standard, if, as Finnbin argues, all mandatory standards under Section 104 have to be based on a voluntary standard. And even if the text were susceptible to Finnbin's interpretation, it would really flout the purpose of the Consumer Product Safety Improvement Act, which was to remove durable infant or toddler products from the ordinary regime of reliance on voluntary standards and direct the issuance of mandatory standards for those products. That Finnbin's argument would leave the Commission disabled from exercising the particular authority granted by Congress as to, exactly that set of products for which it is most necessary, which is to say, those for which there's no voluntary standard in place at all. And again, even if this,
just pause there for a second, because Finnbin is arguing that you always have the 2058 authority, and that's where you're supposed to go where there isn't a standard already in place. And under the 2058 authority, although there's more justificatory burden, it isn't just saying rely on voluntary standards. You can promulgate mandatory standards, and I trust have done so in dozens, hundreds, many instances. What is it about the difference between the 2058 authority and the 2056A authority that animates this that makes this case so important for the Commission? Is it so onerous, the process under 2058, and in what ways that are relevant to the Commission?
So it is onerous, but even aside from the need to satisfy the requirement of showing essentially that voluntary standards don't suffice, what's quite important is that the ordinary authorities require cost-benefit analysis, and the statute here requires the opposite. So the Supreme Court's decision in textile manufacturers versus Donovan has a nice explanation of the difference between a cost-benefit standard and a feasibility standard. They're really night and day. And what Congress has said here is we don't want cost-benefit analysis. You don't have to consider whether the costs of regulation is measured by behavioral change and so forth outweigh the benefit. We want you to make these products as safe as they can feasibly be made. It's a fundamentally different standard. And so that is really the basic problem with Finnbin's argument that we should just resort to our more general authorities, is that, Finnbin wants to evade the congressional command that the Commission has to make durable infant or toddler products as safe as they can feasibly be, which is a quite different standard. And again, even to the extent the purpose of the statute doesn't adequately clarify the text in the Commission's favor, the Commission's conclusion that it can issue a standard under Section 104 without waiting for action by ASTM would be entitled to Chevron deference. The Commission, resolved that issue quite clearly, and it is at a minimum a reasonable construction of the statute.
I asked, one thing that confuses me is in 2056A, B1, talking about the sort of voluntary standard process, talks about the regulation of products. And then in B2, which I think might be the first time in the statute, it talks about categories of products. And, I don't think the voluntary standards are doing it, one product at a time. They must have some conception of a grouping of products that they base their standard on, but that's not how it's framed here. And so I'm just confused about what's the difference between a durable product that's voluminous enough to warrant, in numerous enough, I guess, to warrant perhaps a voluntary standard, and then what these categories are that are talked about in Section 2, which would seem to be something categories are drawn by the Commission itself because they're not referenced in B1, and just how that fits into your sort of vision of this statute. Or am I getting distracted?
No, I mean, I think statutories, I think categories is not a statutory term of art. Clearly, the commission has the authority to sort of determine how to break the universe of durable infant or toddler products down into various categories. What the commission did here was essentially to respond to, I think, just kind of an artifact of the way the categories had evolved through the voluntary standard setting process, which is that because sleep products had been separated into, 5 different categories: full-size cribs, non-full-size cribs, bassinets defined as products requiring a stand, bedside sleepers, and play yards. The commission noted that there was a subset of infant sleep products that just sort of fell outside those categories that had been articulated in the voluntary standards. And so what the commission did here, really, you can think of as saying, okay, so there have been these 5 categories defined. We don't think it is appropriate that leaves a subset of infant sleep products completely without regulation. And so we're going to define, basically a residual category of products to make sure that all sleep products are ultimately required to satisfy a minimum safety standard.
Subsection F doesn't use the word category. It describes full-size cribs and non-full-size cribs, even talking about as a product. That's why it doesn't use the word category in the definition of durable products.
Yes, and
so that's why
I think,
I just didn't know what the word category was doing here, but it does seem like you definitely created a category here.
Yeah, and I think, again, category, I don't think is sort of a relevant statutory term of art. I think what the commission's authority, as Your Honor noted in subsection B1, is to regulate products. I think B2 reflects the fact that in order to promulgate regulations, you sort of naturally have to break things down into categories because you're not issuing a standard for one product. But I think certainly the commission has some considerable leeway in deciding how to break down the universe of durable infant and toddler products.
Mr. Winnick, under your view of the statute, well, actually, even under Finnbin's view of the statute, could the commission decide that the 5 statutorily identified categories of infant sleep product are the only ones that are sufficiently safe and just treat that as the universe of infant sleep products? So, and I guess, as Finnbin would argue, so effectively drive all others out of business without any findings, cost-benefit analysis, feasible alternative consideration. But I guess I'm wondering, why isn't that fully open to the commission, and whether it is open to the commission even under Section 104 as petitioners understand it?
Let me try to answer that. So what the commission has the statutory authority to do is issue mandatory safety standards for durable infant or toddler products, right? If the commission hasn't issued a mandatory standard for a durable infant or toddler products, it is not, in any way regulated or banned or whatever you want to call it by, under Section 104. I think what Finnbin frames as the risk, at least so far as I understand it, is actually that the commission could sort of define a broad category of things and say, you have to satisfy a safety standard. And they understand that in this case to be a ban. I think for the reason raised by a question Your Honor asked earlier, Section 104 defines the full scope of the commission's, special statutory authority as to durable infant or toddler products. It doesn't distinguish between standards and bans. And so I don't think it's actually analytically relevant whether something can be thought of as a ban. But, setting that aside, this can't possibly be thought of as a ban on baby boxes. There's nothing.
So putting aside the somewhat tendentious or dramatic use of the term ban, is there anything that would prevent the commission, I mean, maybe this is just what the commission did, from saying, here are these 5 categories, they're actually mentioned in the statute, each one of them has a corresponding voluntary standard, and we think that's the waterfront. And so, mark it under one of these or don't mark it. And that's not, as you say, the discussion was different. And as you described it, it's an artifact of the way the voluntary standard setting process evolved and the regulatory process. But looking at this on a clean slate, just trying to understand the implications of Ms. Hartnett's statutory reading. Is there anything, I mean, it's really a question for her, I guess, but is there anything about that kind of position on the part of the commission that would be impermissible for reasons that I'm missing?
So let me first explain what I think the commission did here, and then try to assess whether it would be okay under Finnbin's argument. I think what the commission did here is essentially just that. I mean, so actually, as a formal matter, if you look at the text of the rule itself, the rule text, what it did was to revise the list of kind of categories of durable infant or toddler products in the consumer registration part of the rule, which is kind of where the commission lays out its categories, to change the one for bassinets and cradles to read bassinets and cradles, comma, including bedside sleepers and infant sleep products. And so essentially what they said is, look, anything that is being sold, marketed and intended for sleep in infants, 5 months or younger, has to, just as a minimum matter, comply with the Bassinet standard. In terms of whether that would be allowed under Finnbin's understanding of the statute, I don't think it would, because the point Finnbin is making, really the central point, is that they don't think the commission has statutory authority under Section 104 at all as to products for which there is not an existing voluntary standard. So setting aside the compact bassinet standard that is now being, issued by ASTM, baby boxes and other, flat infant sleep products covered by this rule are not subject to an existing voluntary standard, and therefore Finnbin's argument is that the commission just lacks any statutory authority over them under Section 104,
But they are, for the very reasons that the commission embraced in its rule. I mean, this isn't the way the commission described it in the rulemaking process, but you're basically at the end of the day saying there is a voluntary standard that applies to them. It's the Bassinet standard.
So that's sort of, the commission wants them to be subjected to the requirements of the Bassinet standard. They are not, as a formal matter, within the scope of that voluntary standard as it's understood by, under the current voluntary standard, because the voluntary standard defines a bassinet, and this is at 790 of the joint appendix,
right,
as a product that has a stand. Yeah.
Right, but it's basically saying if you want to market something, it has to either meet the definition of a crib, of a bassinet or a cradle, a play yard, a bedside sleeper, period.
I think that's a fair summary of the effect of the rule. Yes, it's to say for products marketed and intended for infant sleep that are not covered formally by one of the existing voluntary standards, you're going to have to meet the requirements of the Bassinet standard, including the definition of a bassinet, which is how the rule, imposes the requirement of having a stand or a base. Yes. And again, that is simply to ensure that there's not some residual category of infant sleep products that, simply by virtue of how the voluntary standard setting process has unfolded over the years, do not have to comply with any standard at all.
There is,
there's nothing to prevent it from being like a non-full size crib if they thought that was an easier way to market it, right?
Sure, if they could alter the product to comply with a definition of a non-full size crib, they would then be within the scope of the non-full size crib standard, and therefore, definitionally not within the scope of this standard. I think that's right, but it has to be one or the other.
Sorry, Justice Katsas had a question.
Just on the word product does seem to be a term of art, and there are maybe some clues, at least suggesting that the commission is supposed to regulate at a pretty granular level under Section 104. To me, product has at least a connotation of reasonable interchangeability from the perspective of a consumer, and maybe more directly on point, there's a statutory definition of durable infant toddler products, and all of the examples are bassinets, cribs, play yards, bedside sleepers, right? Very narrow. So why doesn't that at least suggest that commission is supposed to proceed at that kind of level rather than abstracting all the way to infant sleep products?
Well, first of all, I think the categories of products listed in the statute are not all that narrow. But assuming there is such a thing as
relative to infant sleep products, they're pretty narrow.
Understood. I mean, I think what the commission did here, I mean, the rule doesn't sort of treat infant sleep products as a unitary whole. It recognizes that there are distinct types of infant sleep products. And so what it has done, I mean, in pursuant of its authority to promulgate standards for categories of products, is to say there's going to be a rule for this category, for this sort of residual category of products. The standards in that rule are going to apply to the various different types of products encompassed within this category. So I think to the extent Your Honor is correct that what the commission has to do is issue standards for sort of narrower products. The commission has done that here because it has recognized that the category as to which it's issued a standard encompasses various types of products.
Oh, yeah, I would have thought, sorry, I lost B2 would show sort of the opposite of what Judge Katsas was suggesting, because even though product is a term commonly used throughout this statute and the Organic Consumer Product Safety Commission Act, what you've been ordered to do is to produce standards for product categories. And while F defines some products, the commission is supposed to be regulating every 6 months categories quite expressly, as you said. So I think that has to have some meaning. It didn't, for some reason, they didn't follow through on the language used in B1 or in F and say regulate no fewer than 2 products every 6 months. And so it does seem to me that they were doing something more here. And given that standards tend to focus on products, even though products is more than an individual company's individual version of an infant seat or something like that. They are, as he says, this fungible or interchangeable versions of the same idea of a product. The leash here is the command here is not even a leash, is to go broader. But that's not always what the commission has done either. So that's why I was confused from the beginning. But I don't know how. Yes, I don't know how we would say we're meant to go at that you have to go to granular level under the statute reading B2.
So I certainly agree with that understanding of the commission's of what the statute says about regulating products. I do think, I'm not sure I understood the question to suggest that that isn't what the commission did here, but I do think that's exactly what the commission did here, is to say there's a category, a residual category of products that happen not to fall within the scope of the existing voluntary standards because, I guess just sort of how those evolved over the years. And so we're going to take that whole category of products and subject it to the minimum requirements of the Bassinet standard.
Then the product becomes, is this sort of the kitchen sink category? Because it seems to me it's actually, the commission here has grouped together things that are profoundly dissimilar. Obviously starting with inclined products, which is a very different category from sort of at least flat sleeping products for a large variety of reasons. And I doubt are grouped together in consumers' minds. There's all kinds of inclined baby products. And then even within the flat products, there are the sort of soft-sided in-bed sleepers. And then you have these sort of rigid sided flat that seem like they're exactly what you are supposed to put babies into. They're firm sided, they're flat, they've got the right mattress, they've got the right spacing if they have railings, or they just don't have railings at all. They're everything you want, except they're not on a stand. They're bassinets without a stand. They're more portable. They're portable. I mean, one of them is even a portable bassinet. Which seems to be a whole world different from either an inclined product or these little pillows that go on beds. And yet I didn't hear the commission linking these things together other than, well, this is the stuff we haven't got, no one's gotten to regulating yet. And I don't know how that's a viable category as opposed to should this have been divided into smaller categories. It just seems quite that there wasn't, if I didn't see, you can point it to me, I didn't see a lot of reason in explaining why we are treating baby boxes the same as which are very high sided and not naturally used in the middle of a bed. Someone could, I guess, but really quite different from these little pillows that go in the bed or inclined products. What on earth is a rationale for grouping all this stuff together other than let's just do it all at once?
So, Your Honor, I think the relevant question in this petition for review is, are the requirements of the Bassinet standard reasonable or arbitrary and capricious as applied to baby boxes? Everything else is not jurisdictionally before the court because Finnbin doesn't have standing to challenge it, and the rule is certainly severable. As to baby boxes,
so is that a prod? Is that so? So are you now looking at the product level, or are you defining baby boxes as a category? Because you said in response to earlier questions, this was our category of sleepers, infant sleepers that weren't covered in any way, shape, or form. These infant sleepers, all different variety, that aren't covered by existing regulations. That's the category they're regulating here. And now you're saying we should look at not a category, but a product, and the product is baby boxes.
So a couple of things. First of all, I agree the category here is infant sleep products. The product is baby boxes. I think the question before the court, the only question the court has jurisdiction to address is the rule arbitrary and capricious in the requirements it imposes on baby boxes. I think Finnbin doesn't have standing to raise arguments about whether the rule is arbitrary and capricious insofar as it requires other types of products to meet the Bassinet standard.
So does that mean we need to look at what in the record there was about risk of harm just from baby boxes?
So Finnbin certainly makes arguments that these requirements are arbitrary and capricious as applied to baby boxes. They're not, and we should talk about why, but I want to make sure to address sort of the general question first. I mean, everything else is just sort of not jurisdictionally before the court. And the fact that the commission was certainly addressing a broad residual category. What it wanted to make sure to do was, ensure that no infant sleep products were sold without being subjected to a minimum standard. As to baby boxes in particular, Your Honor is certainly correct that they're different in some respects from things like in-bed sleepers. But I think where that plays out is that they already meet many of the requirements of the Bassinet standard, or at least I'm not aware of reasons they wouldn't. So they meet the side height requirement. I think I see no reason they wouldn't meet the strength and stability requirements, although I'm not aware of, test results or something like that. Really, where the rubber meets the road here is the requirement that they have a stand or a base. So yes, they are distinct from some other types of infant sleep products, but because they already meet those elements of the Bassinet standard, they avoid those types of hazards. Now, as to whether it is rational, reasonable, not arbitrary and capricious to apply particularly the stand requirement to baby boxes, the answer is yes, it is. And that's true both on the basis of the evidence in the record and frankly, just as a matter of common sense. I mean, the commission didn't
before
have
we
to
go to
have
common sense, because if we're supposed to look at this as, and I understand your jurisdictional points, I know they have their arguments about why we can't look at in-bed sleepers, but for this purpose, let's assume that we're looking at it as you wish to, through this jurisdictional lens of just baby boxes. What in the record was there that's we'll take as a given also that we know they meet the flat sleeping requirement, we know they meet the height, the side height requirement, and we'll take as given that they meet the stability and sturdiness requirements. Then what in the record shows that baby boxes need, as opposed to portable bassinets, need a stand to be safe?
So there is not evidence in the record of harms specific to baby boxes. That isn't surprising because baby boxes are sold in incredibly small numbers relative to the other types of products. I think the statistic in the record is 20,000 a year before this.
Yeah, but for how many years? How many years have they been marketed in this country?
I actually don't know how long they've been marketed in this country. Obviously, globally, they've been around for quite some time.
Well, to say that there's not that many, that it's relevant not to have any evidence, and say 20,000 a year sounds small, but if that's been going on for 20 years, and maybe counsel for Petitioner can tell us how many years they've been marketed in this country, that could be 100,000, 200,000. These could have been out in used by parents in the United States. And so that seems like a relative sample to know if someone been injured or, God forbid, a child killed by this product.
So the sample of data that the commission was looking at was not, 20 years or globally. It was looking at 2 years worth of anecdotal reports, basically in the United States, largely reports from retailers and manufacturers, which amounted to, I think, 183 incidents with, 16 injuries and 11 deaths. So this was not, I will hasten to add, this was not, it didn't attempt to be a kind of comprehensive survey, much less a statistical one. But the point is, this court has made clear agencies don't have to meet some standard of, massive empirical
but they have
evidence.
to have some standard of reasonability. And so if you have a product, so if we're looking at this just through the lens of did they treat baby boxes in an arbitrary or non-arbitrary and capricious way from your viewpoint, and you tell me, well, they've effectively banned them because they just are designed not to have a stand. So you can't have baby boxes with a stand or not baby boxes. They're bassinets. And so you've said this product that you have, as you've had it and as you've had it for however many years, decades that you've been here in the marketed here in the United States, you can't exist. And we're going to do this based on a year or two's worth of anecdotal evidence, not a bit of which involves baby boxes. And it was a choice by the commission. They chose that window of information. They chose that. They could have chosen to do a more extensive survey. And they can't claim there was some emergency about baby boxes. And so explain to me how that is reasonable.
So let me address
baby boxes that way.
Let me add as a threshold matter, I don't think there's anything inconsistent with the nature of a baby box to have a stand. The other major domestic manufacturer of baby boxes is in fact developing and offering for sale a stand for its baby boxes.
Well, we don't know that the CPSC has approved that stand, do we?
Fair enough. But as to the question,
and they're only doing it because the rule requires.
To be sure.
And is the baby box removable from that stand?
I don't know.
I've seen a picture of it. It looks like the baby box can go in it or go out of it, at which point we're right back where we started.
I have the same impression from what I've seen of it. But
okay, and so then if what you're saying has to be permanently attached stand, then you are eliminating baby boxes. So I'm not sure you've persuaded me yet that you're not eliminating baby boxes.
So as defined as something that doesn't have a stand, sure, this wouldn't allow baby boxes to be sold without a stand. As to why that was reasonable, what the record shows is that flat sleep products can and do fall off or fall over when they are placed on pieces of adult furniture like beds or couches. And would it have been nice to have more data? Sure, but you would need more data.
Nice is whether it's reasonable, because these are not as small as like a car seat or something. I mean, these are pretty decent sized boxes here that I don't know that you would just set it on a couch given its length and width. I mean, you could, but it's pretty hefty. You wouldn't sit it on a kitchen counter or kitchen table unless you clear off the entire table, unless given its height. So do we know that people are putting baby boxes in positions? They're not generally they've marketed them to put on, to tote around the house with you and put wherever you go, and as any place other than the floor. I mean, if they had written in big letters on the box, only set on the floor, stable surface like the floor, or just say if it only used on the floor, we'll make it simpler. That was how it was marketed, for floor use only. Then would you have still been able to claim you've got a problem?
So I think the question whether a warning can be sufficient to sort of eliminate all foreseeable misuse of a product is distinct. And I frankly don't know the commission's view on that. I think it is reasonably foreseeable that baby boxes are going to be put on couches and beds. They're not that big. They're about 2 feet long and about 1.5 feet wide. And, what the commission noted from the evidence in the record.
They're more than 2 feet long. So
it's 27 and a half inches long. Yes, exactly. Right. So just over 2 feet long, just under 1.5 feet wide.
Yeah, that's pretty big box. It's not.
I agree it's not small, but I also think it's perfectly foreseeable that parents who are routinely putting an infant into and out of this box are not going to want to bend down to the floor all the time. And more to the point, there was evidence that there's plenty of evidence in the record of other flat sleep products that are routinely put on beds and couches for exactly that reason. And it's why
they have the same type of dimensions.
I don't know how the dimensions of a baby box exactly compare to something like an in-bed sleeper. I think it's fairly similar. I mean, babies are a certain, length, and I think an in-bed sleeper is going to be roughly 2 feet long and a foot and a half wide. Whether it differs by an inch or two, I don't know. But yeah, I think we're talking about things that are essentially the same size, at least in terms of length and width, and not height. So there's no reason parents would be putting in-bed sleepers or other flat sleep products on beds or couches, but they wouldn't do that with baby boxes.
Because I saw on the record, and you can tell me if I'm wrong, one instance of one of these rigid-sided flat sleepers that I think was put on a couch and maybe pulled over by a toddler. One instance. Everything else was either undescribed, with sufficient definiteness, or appeared to be these soft products or inclined products. That's what it seemed to be the evidence as I saw. You can tell me if I'm wrong, and I missed a whole category of rigid-sided from flat sleep products that were getting pulled off couches. I didn't see it. And it seems to me, why is it reasonable for the commission to jump to eliminate that product? You may manufacture something different. It can be rectangular, like your box, I suppose, but it's got to be completely different. A stand, something on a stand. Why is it reasonable on the record, as I've seen it, and tell me if I'm wrong for sure, but if you don't disagree, then on that record to jump immediately to eliminate it as opposed to try a warning? Or maybe, your client's the expert. There may be all kinds of other things they could do that would be helpful.
The commission's statutory obligation is to issue mandatory standards necessary to make these products as safe as they can feasibly be. Not, satisfy a cost-benefit analysis in which you might look to whether some less burdensome alternative like a warning would suffice, but to make them as safe as they can feasibly be. And given the basis, both in the record and as a matter of common sense, to think that parents are foreseeably going to place these things on beds and couches from which they can easily fall or tip over, it was quite reasonable for the commission to determine that what would make baby boxes as safe as they could feasibly be is to require that they have a stand or base so that people don't have to put them on a bed or a couch.
Did the commission consider, it seems like if you're going down that route, you have to stop and think, obviously it's harder for, I guess, the 2-year-old male toddler to tip over something on his stand. I don't know whether on average all siblings are 2 years older as opposed to 3 or 4 who could easily, or even a big dog who could easily knock over a bassinet on a stand, as compared to, yes, if this box gets knocked over on the floor, yes, it could happen. But one, the dog's not going to knock it over, and 2, they're not falling very far. They're essentially rolling over at that point, as opposed to if you're up on a bassinet stand and get knocked over, you're falling feet and feet and feet. And it feels to me like this record is really, if we're looking at it through the lens you want us to, and I completely appreciate your jurisdictional arguments in that regard, that there's just not enough here, or just help me understand. I'm really, really struggling with this because I understand the importance of this safety. I really, really do. And the commission's very, very high charge here. Don't they need to spend a little more time, get a little more of a record, and think this through as to this particular category?
So, Your Honor, as to whether stands are safe or less safe, I mean, I think the points Your Honor is making about whether it is less safe to be raised off the floor could equally be made about bassinets. And I won't say I haven't.
Well, that's the point here. These are bassinets that go on the ground.
No,
that's
right.
I've never studied them before. And
but
volunteers have said neither.
Yeah, my point, though, is that bassinets have been required to have a stand for years and years, both through the commission and through ASTM.
Because that's how bassinets were. That's how everyone thought bassinets were from before the statute was enacted. And then innovation comes along and they go, well, actually closer to the floor is a lot safer. Maybe that's what they thought in marketing this. A lot safer, a lot harder to knock over. And yeah, it could be pulled over by the toddler, but it's not going to have the sort of same physics for tipping something over, and it's certainly not going to have the same harm. And so I just, again, why is it reasonable that they jumped to this new category, but didn't find specific evidence and didn't do more study? And it's not that nobody wants to wait for the first dead child. I get that too. But this is what I'm struggling with, is their duty, their high duty here, with the really pretty empty record as to baby boxes on all these different levels.
Yeah, I think there are really two questions here. One is the stand a good thing or a bad thing? And two is, what basis did they have to make baby boxes satisfy the Bassinet standard? As to whether a stand is a good thing or a bad thing, I think that's a highly technical question committed to the expertise of the commission. And frankly, the same conclusion has been reached by ASTM that, although it means the child is off the ground, a stand is a good thing because bad things can happen to babies when they fall out on the ground. It's much easier to knock them over on the ground. So I don't think that's
was that part of the original Bassinet? Okay, I'm just clear. So this is helpful. So as part of the original decision to adopt bassinets, they made a specific decision that we want them on a stand. I know why they want a stable stand. Of course, if you're going to have a stand, you want it to be stable. But there is in that record, which we don't have in front of us, evidence that they made a specific determination that being up off the ground on a stand is safer than being on the ground. I'd assume they hadn't because there wasn't on the ground options at the time. But if you're telling me that's what is in the Bassinet record, that would be very helpful to me.
Yeah, I don't want to represent that that's in the Bassinet record. I don't know that that's in the Bassinet record. My point about the bassinets is really just that if it were really safe, if it was unsafe to have them elevated, if it was safer to be on the ground, then I think, frankly, it would have been in the commission's authority to say, no, actually bassinets can't be off the ground.
Did they have that option? Did they have that comparator at the time they adopted the Bassinet standard?
Yeah, I mean, baby boxes,
relevant volume?
As Finnbin notes, baby boxes have been around for years and years. I don't think that what has happened here is some innovation to say, actually baby box or bassinets are dangerous because they're elevated, and so we should have something on the floor. The baby boxes have been around for years and years, and the point was always, I think Finnbin makes this point. I'm just asking
what the commission considered with the bassinet. Did it make, if you can, you don't have to tell me now because I know that's not the record in front of you. So I'm sorry. I don't mean to be ambushing you, but if it's some, maybe after argument, if you want, if there is something from the bassinet process itself that made a determination that off the ground, for whatever reason, maybe they didn't have this specific comparator, is better because you don't get tripped over, you don't get kicked, whatever. So that off the ground is safer than on the ground, even if you've got the same rigid sides, flat sleep, this kind of stuff. You've got all things being equal, up is better than down. That would be helpful. But if it didn't exist because it just wasn't before them at that time, that would be helpful to know too, because now it is before them.
Yeah, I hear the question, and we'll take a look at it. I've just noticed that baby boxes, I think the value proposition of baby boxes has never been, these are really wonderful and safe because they're on the ground. The proposition of baby boxes has always been, these are, simple, at least in some forms, relatively inexpensive, and they're safe, flat sleep surfaces. Nobody disagrees with that.
And stable. But she even said stable in describing it. So I think, and if it's the commission here that said, no, get them up off the ground. So it's the commission here that has to have the reasoning. They did talk about it's a stable surface when it's on the ground, to be fair to them.
That's right. The way in which it's unstable is if you put it on a bed or a couch, which foreseeably can happen. I mean, just on the sort of question whether it is like some great harm to require baby boxes to have a stand, to the extent it makes them more expensive to do that. I mean, I would just note it is not correct to suggest that this is going to deprive people of inexpensive options for safe sleeping environments for children. I mean, the preamble notes that the price of a baby box on the market, I think it says 50 to 75. Finnbins actually were 75 before they were taken off the market. And the preamble also notes, I think, at the preceding page, that there's plenty of safe bassinets that meet the bassinet standard.
Sure, no, I get that. That's not reasons for taking this. This question has started as reasoning for what they have done to baby boxes, which is ban them unless they are a different product altogether. Because you said the product now is baby boxes, which is different than the product bassinets as defined as things with a stand.
Yeah, and I think at the
They
end of the
banned
day,
that product.
I think at the end of the day, the question is whether it was reasonable for the commission to say that baby boxes need to have a stand in order to be as safe as they can feasibly be. And bracketing for a question, bracketing for a second, the question whether a stand, generally is a good thing, which I think it is. I think that's evidenced by the long history of the Bassinet regulation. But bracketing that question, it is reasonable on the basis of the evidence in the record and common sense for the commission to say people are going to foreseeably put these products on beds or couches because they don't want to have to bend down to the floor every time. And when they do that,
Are you talking about the commission articulating this common sense principle?
The commission,
we don't get to use our own common sense. I hate to say it, but we don't get to use our own common sense in this agency review.
What the commission said, its basic rationale for the stand requirement is at J759. They say the requirement to have a stand and to be raised off the floor mitigates the risk that baby boxes are similar. I don't think they single out baby boxes there. Mitigates the risk that flat sleep products are going to be placed on elevated surfaces that may be soft and less stable, surfaces like couches or adult beds from which they can easily fall. That's the commission's rationale. I acknowledge there was not in the record some huge volume of instances where a child was injured in a baby box from that.
Are you aware of anything other than the one reference to a
I'm not.
Bassinet, I think. Okay.
I'm not. But my point is what the court has said in many cases is there's not some general requirement of a large body of evidence or statistical analysis or anything like that. Agencies have the power to act prophylactically. They need not suffer the flood before building the levee. Agencies can, within their discretion and their expertise, identify risks in the world and take actions reasonably calculated to.
That's a very valid point. And even more so than waiting for floods and levees. We don't want to wait for children to be harmed, certainly fatally at all. But what about the separate question of, do they need to go this far as a complete ban?
I think what they determined and what the statute provided for them to determine was that the way to make baby boxes as safe as they can feasibly be is to have a stand. If they were exercising their more general authority under the Consumer Product Safety Act, then they might well have to consider the question whether a less burdensome alternative like a warning would suffice.
Do they not use warnings for, do any of the other, and this might just be, the answer may just be no, do any of the other mandatory standards that the commission has adopted for infant and toddler products include warnings as a feature?
I don't know the answer to that question. Okay. Yeah, I don't know the answer. And
I just don't know if, like in this context, warnings don't matter because everyone's too sleepy to read, or this from 0 to 5 months, or because they're all warnings all over all kinds, not infant and toddler, but certainly 3 and 4 year old toys about small pieces and things like that. Warnings are very much relied upon by the CPSC. I get that's not under 104, so that's why I'm asking the question for 104. If they've made a decision here that warnings are not, because of our unique mandate, we're not going to rely on warnings, that would be helpful to know.
Warnings are not in short supply, and I don't know whether the commission has a view on sort of warnings as a requirement specifically under Section 104. But I think the sort of, for present purposes, the salient point is if Section 104 allows warnings, and if warnings sort of make the product even safer, then great. But the relevant question is not, could the commission sort of have gotten almost to the same place or just nearly as good by having a warning? The question is the product as safe as it can feasibly be? And the commission's determination, again, in its expertise, was that baby boxes can feasibly be made safer by coming with a base or a stand. And therefore, that was the requirement that the commission imposed on them.
You had started in the very early part of your argument emphasizing the plural in the statutory requirement to assess existing voluntary standards and adopt standards that are equally or more stringent. And I'm not sure you got a chance to actually drive that point home. What were you taking from that? I don't remember you making that particular version of argument in your brief. Where do you get with that?
The only point I was making, Your Honor, is that the statute is not, Finnbin sometimes argues as if the statute says the commission shall look at products that are regulated by a mandatory standard and determine whether to take that standard and make it mandatory or make it more stringent. And the only point I was making was the statute is written to tell the commission to undertake a broad project. look at the set of durable infant or toddler products, look at the set of any voluntary consumer product safety standards, look across the waterfront, and then take those standards and subject all durable infant or toddler products either to mandatory standards that are substantially the same as the voluntary ones or are more stringent than the voluntary ones.
Does that help you in what I think is the key, overcome what I think is the key challenge that Finnbin is making, which is only where there's a voluntary standard? And that's where I thought you were headed, that somehow when you look at the body of products and the body of voluntary standards, that somehow the gap filling is more plausible when teed up with that framing.
I mean, I think it helps in the sense that the commission's statutory direction was to look at the full set of durable infant or toddler products. We think it's perfectly textually natural to say that mandating that a durable infant or toddler product satisfy a standard is more stringent than the status quo ex ante, that it's to satisfy no standard at all. And the point of the breadth and the plural language is that Congress didn't say, go look at the voluntary standards and determine whether to make them more stringent or impose them as is. It said, go look at the whole set of durable infant or toddler products, look at the existing standards, determine what to do. And then again, to the extent there's any doubt in B1 as to whether the commission's authority extends to products that aren't subject to an existing voluntary standard, I think it's resolved by B2, which clearly directs the commission to impose mandatory standards on all durable infant or toddler products. I also think it's further bolstered by B4A.
Just one quick question on, do you read substantially the same in Romanet I, which I know is not an issue here, as having only allowed the type of de minimis standards that Ms. Harton has referenced, or could that include sort of changing the definition of bassinets?
I'm not aware of a position the commission has taken on that, and so I don't want to sort of commit them to anything. Just to sort of as a textual matter, I think I have essentially the same reading as Ms. Harton does of that. I think substantially the same could refer to variations in the sort of the language that don't alter the substance or things like that, or maybe minor substantive variations. But the commission didn't take here, at least.
I know it definitely didn't do it here, but I'm sorry, do you think it could sort of, if you expand the definition to include things that are at least marketed as bassinets, even if they don't have stands, that'd be more than substantially the same?
That might be plausible, particularly if the commission hasn't done that. Obviously, I think that it's textually plausible, I think, to say that, certainly at least some expansions in a standard, whether in scope or stringency, could be sort of substantially the same, that there's some play in that word. Again, I don't have the commission's
They haven't had
view
occasion
on
yet that you're aware of to sort of interpret that.
That's right. I'm not aware of anywhere they've opined on sort of their formal understanding of what that provision would allow them to do.
Looks like they do warnings on bassinets and cradles, for sure. Like, don't use a different pad, don't put pillows and things in here. So it seems like warnings are an acceptable regulatory tool, even under Section 104.
Yeah, I think that's right. And again, the question as to whether a warning would suffice just isn't presented here, because the mandate is to make the product as safe as it can feasibly be. And so it's not relevant as it might be under the more general authorities, whether a warning could get you almost all the way there and in a less burdensome fashion.
Can you just quickly, can you walk me through why you think B4A helps you? It says the commission has to provide notice when it adopts a standard based in part on a voluntary standard. How does that hint that we could be talking about an expansion in scope as well as an expansion in stringency, or what is it about that you think strengthens your case?
It's that I think it reflects the possibility that you could have a consumer product safety standard issued under Section 104 that is not based in whole or in part on a voluntary standard. If every standard necessarily had to be based in whole or in part on a voluntary standard, I think Congress would have likely written B4A differently to say simply, when the commission promulgates a standard, it shall notify the organization that issued the underlying voluntary standard or something like that.
The negative implication is there could be standards that are based, 104 standards that are based neither in whole nor in part.
That's correct.
Okay.
Exactly. Yep. Unless the court has any further questions, we ask that the petition for review be denied.
Thank you very much for your endurance. Ms. Sarnia will give you 3 minutes.
Thank you, Your Honor. I'll try to use it well. I wanted to just direct the court back to the just on the key point of, excuse me, what does the statute mean? What is it in terms of the timetable provision? I would direct you to House Report 110-501, which we cite in our brief, although don't spell out this exact point, but pages 32 to 33 of House Report 110-501, I think is a good example of the report help clarifying what's at issue. They talk about both that they have to assess the effectiveness of the voluntary standards, and then the timetable must complete the rulemaking and promulgate a mandatory safety standard for 2 of the 12 products every 6 months. So I think what you'll see from looking at that House report combined with the statute is that there were those 12 products listed to start. Those are the ones that were out there that people were worried about making mandatory. Go through those 12, do them on this timetable, and then thereafter they've allowed other standards to come in. So I really do recommend this report to help understand how the timetable worked and this whole issue of the categories versus the products. It becomes a lot clearer. Chevron does not apply here because the agency's never understood this to be its authority until the rule in this case and the litigation position is taken here. Our brief explains at length kind of how this has never been the position taken before. And under the authority that they're describing, they could literally redefine categories to sweep in. It's not clear what the limit would be on how they could redefine the voluntary standards to encompass new products, new scope that had never been subject to a voluntary standard. On your questions about the stand, that was not, so the Bassinet rule is in the record. It's in the record at JA 16, and it goes, there's no description in that Bassinet standard explaining why a stand was safe or not. A couple other key points though about the Bassinet standard is to your question about what does this substantially the same mean? One possible answer would be at Joint Appendix 19. There's an example there about like multi-mode products where you could use it as both a bassinet and not. And they said, oh, we'll clarify a part of the voluntary standard. We're going to just clarify that a multi-mode product must meet the bassinet standard when in that mode. So that's an example where the voluntary standard wasn't exactly saying it the same way, but it was actually making the same thing, but with a little bit of a tweak there. I also would just note there is a carve out from the Bassinet standard for not only the inclined sleep products, but for some flat sleep products that existed at the time, 2013. And this includes the Moses basket. And that is all available at Joint Appendix 18, where if you want to see the idea that the commission itself understood this to be a different product class. In terms of
did it mention baby boxes then?
It didn't mention them then. Moses basket was the main. Sorry, I want to make sure I get the page right on that. Sorry, it's actually Joint Appendix 16. Okay. And that was it was basically portable cradles. And so that was kind of what the conception was, at least at the time. Our company has been around for about 6 years. Baby boxes have been generally available in the United States for around 20 years. But this is kind of a wave of products that has emerged more recently. And again, whose innovation would be ended with this. I guess I would just end. I can give you more.
So just to be clear, don't worry here. So, yeah. No gun goes off when the
understood.
At the time of the Bassinet standard, all bassinets had stands. I mean, that's just what bassinets were at that point. They may have been good or bad stands or things like that, but the concept of a portable bassinet, other than maybe it was implicated only by like this Moses basket at the time, and they carved out portable.
Yeah, I would. So this is at Joint Appendix 16, and it's under the product, because this is talking about the Bassinet standard as of 2013. And it talks about the voluntary standard and how it defines it, which is bassinet cradle as a small bed, blah, 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 supported by freestanding legs, a stationary frame stand, et cetera. So it kind of explains it by reference to a stand. And then it goes on to say that, that cribs, Moses baskets, and products used in conjunction with an inclined infant swinger stroller and just are not included under the category of bassinets. And it goes on to describe a Moses basket as a portable cradle. As with other bassinets and cradles, Moses baskets are not intended for use after a child can push up. So it's basically kind of a primitive, circa 10 years ago, kind of understanding of what the leading product was of that type. Since that time, these additional products have come to market, which is why there was this in-bed sleeper standard being developed, as well as I do understand from my client, a baby box standard being considered by the ASTM. So those things were in progress at the time that this rule then decided to sweep them into this rule. In terms of the warning label, you're already addressed that, but I'm just looking at my record of the almost 50 rules that have been issued under Section 104, and there were repeated examples of Section 104 power being used to do a warning label here that wasn't really even considered as an option in the rush to sweep the products in. There was an extra reference made to agency expertise. I do think another important point here is the record differential between the inclined sleeper record and the non-inclined. There was an actual expert that was commissioned to do things. There was a different type of agency expertise at issue. Here, there really was just trying to put these incidents together in some pattern that they felt could try to justify everything. And I do, just on the point of the standing, which is important to my client, because we actually do want to be able to be a baby bot, to be an in-bed sleeper. I think I'm not trying to walk myself into an out of the arbitrary and capricious argument you were making, Your Honor. But I think it's interesting the government is by reference saying, oh, we can justify excluding the baby boxes because they could be used on a bed, but then also trying to prevent us from actually having standing to bring the claim with respect to the entire category that's banned. And I do think we're properly before the court on that. I would request an opportunity to put in a declaration. And I do understand that the Juvenile Products Manufacturers Association would want to join to the extent there was some issue with the standing that's come to date at the end.
It's a little late to have somebody intervene after oral argument in the Court of Appeals. So,
well, understood, Your Honor, but it was not really a standing. I mean, this was kind of in the back of their brief at the end about this. It's argued as a severability issue, not as a standing issue. We believe we do have standing with respect to the entire universe. And like I said, citing that, the case of I'm going to not have it totally on hand here, but the cases
we have your brief on it. We understand.
Well, especially but the government citation of North Carolina versus FERC, I think is important because there it's where the agency treats it as a unitary matter to start. We should be able to challenge it as a unitary matter. And so I really do think that we're here properly before the court on the whole category. And so I guess with that, I would just say that.
Can I ask one other thing before you wrap up? And that is, did your client, I know your client submitted comments to the commission objecting to this exercise of its power. Did your client suggest any alternative forms of regulation for baby boxes?
I think our client has been actively participating in the ASTM process for all of these things to find the right. Yes. So yeah, I think the alternative.
It's a different question, not whether you submitted things to ASTM. Did you submit in your comments to the commission? Did you say, hey, all you need for our baby box, for baby boxes to be safe is a warning label? Or I am the opposite of any of these engineers here, so I don't know if there's some.
No, I'm just looking back to our comment.
Recommended.
Yeah, that's 679 to 680.
Mm-hmm.
I think our main point was that there was just zero evidence of any safety issue to the point of where any actual additional. Yeah, and that's just actually the case. And I think that more broadly, the record reflects the in-bed sleeper people all trying to work together to figure out, are there ways we can actually through warnings or other circumstances mitigate this? And I think it was coming out of a true felt need that, and the commission itself recognizes it in the rule but doesn't grapple with it. 37% at a minimum people regularly bed share, and to the extent that we're taking away products from people, especially people that may not have the means to have more luxurious products to make those situations safer, that is a command of infant safety. And I hear, unfortunately, the commission lost sight of its actual mandate, which was to help advance infant safety in sort of a rush to take off the market products that it feared might have a consequence that if they had been able to study it further, they may have been able to mitigate the risk and actually make infants safer. And that's why we respectfully submit that the rule should be vacated with respect to previously unregulated flat sleep products.
Colleagues, have any further questions? Okay, thank you. Thank you very much to counsel for the lengthy arguments we took you through. It's very helpful to me at least, and the case is submitted.
Thank you, Your Honor.
This honorable court is now adjourned until Thursday, March 3rd at 9:30 a.m.